So, if you're afraid that one of your loved ones or family members has lost the power of self-control with respect to alcohol or drugs, we can help you in Florida. There's a process called a Marchman Act. Now, I've previously spoken about Marchman Acts, and in Florida, this process is very complex. So today, I'm going to talk about the duties of the court upon your filing of a petition for involuntary services. So when this happens, first the court has to determine if the respondent in the case, who's your loved one, has counsel or has a right to counsel. And in this particular case, if they don't have the ability to pay for counsel themselves, the court is going to appoint an attorney to represent them until the petition is dismissed. Now, once you've filed the petition for involuntary services, it's very important that you have everything lined up because the court is going to schedule a hearing within 5 days on your petition. So you need to have the treatment facility lined up. You need to have any other kinds of mental health services lined up for the respondent, whoever that is, whether it's your spouse, whether it's your child, whether it's your friend. So it's very important that you know these details ahead of time so you're not blindsided and scrambling. Now, your loved one, the respondent, they need a copy of this petition. So they're going to see what you said about them. And it's very important as part of the process that they recognize what's going on and why their loved ones are concerned about them under these circumstances. Now, the court's ultimately going to have a hearing on the petition for involuntary services. So this is governed by 397.6957, and this is a complex statute in Florida. Now, like with the other statutes, there's really not any case law that's really appealing this. But the court will determine if you or your attorney has proven by clear and convincing evidence that your loved one is in need of help and that this help should be involuntary. Now, when they go ahead and take a look at that, you need to explain and have evidence to prove the whole history of how they've needed substance abuse help, and in particular, the recent history. So be prepared to have witnesses to testify, and you can testify, or have other types of evidence. In many of these types of cases, we presented videos, we presented testimony of witnesses, we presented photographs. They could be of drugs the person is using, they could be of them behaving, they can be of them driving erratically. There are a number of different things that can occur, but you need to have that, and you need to be able to present that to the court so that the judge can determine if you are in fact correct that your loved one needs involuntary help. Now, you have to prove that because of the impairment, your loved one is unlikely to voluntarily participate in the recommended services or is unable to determine for him or herself whether or not services are necessary, and without them, they're likely to suffer from abuse or neglect, and they're likely to cause substantial harm to themselves as well. There are a number of other factors that the court looks at, but that's the synopsis of this. Likewise, their refusal to voluntarily receive care is based upon judgment so impaired by virtue of the substances that they're incapable of appreciating their own need for care or making a rational decision regarding their need for care. The court is going to need to hear from the qualified professional who did the assessment of your loved one. Usually that's a report from the Marchman Act receiving facility, but it could be by an independent professional who's properly licensed, who can make that determination. And at the conclusion of the hearing, the court is going to determine what has happened, if you've met the burden, if your loved one is going to go to treatment, and where they're going to go to treatment. So that's very important that you have, again, everything lined up. Most of my clients end up going to private facilities, but this isn't always the case, and there are some good public facilities as well that your loved one can go to. Under 397.697, there's going to be a court determination and the effect of the order for involuntary services. Again, that is by clear and convincing evidence is the burden of proof that needs to happen in these particular cases, and the court can determine that your loved one needs to have treatment not to exceed 90 days. And this is for the initial petition on this particular case. So you need to have everything lined up. And we can discuss a different day on what has to happen if your loved one is in need of longer-term services. A lot of times I see Marchman Acts filed in conjunction with a petition for dissolution of marriage or for a guardianship action. There are many different reasons why a Marchman Act might need to be filed. You can click on the link below or give us a call today, and we can have a discovery call to discuss how to best help you and your loved one in this sensitive situation. Thank you.